Okay, so this is another important concept that we are going to learn today, which is on how to calculate priority dates for different claims in a complete specification that gets examined. And second is how to calculate the term of a patent, meaning for how long the patent is going to be alive, for how long the rights of the patentee shall accrue, that it can stop others from misusing or exploiting his invention. All that we are going to learn. So, two important concepts. First, I must tell you that the priority date and date of filing are two very different things in the context of how, when you calculate the term of patent is when date of filing is accounted for. While the priority date is important from the perspective of finding out whether the invention for which you are filing a complete specification or which you are getting examined from the patent office, has there been a prior disclosure before you went to the patent office and filed a patent application for that particular subject matter? That is where priority date gets important, finds its importance. So let's say if on a certain X date you go to the patent office, file your patent application for subject matter Z, then anybody who may have come before your priority date and filed for a patent application, or it's published in some journal article, in research thesis, or wherever around the world or anywhere in any part of the globe, then that person can actually kill the novelty of your invention and your invention may not get a patent granted on that. Similarly, if let's say you have a priority date X for a subject matter Z, for which you are prosecuting your patent application. And if anybody comes later than your priority date, then your patent application would become a prior art against the later filed patent application. So that's where priority date becomes important to check the prior art and whether something may be novelty destroying or not. While you pick up the date of filing, which you also call as DOF, date of filing, to identify when the patent is set to expire, when 20 years are going to be over. So let us first pick up on the first leg of the presentation, which is calculating the priority date of the claims. Uh, this has been covered in section 11, and section 11 has up to 8 subsections. Section 1 and 2 we are going to cover in this slide. And primarily, it says that in every complete specification, whatever are the number of claims, let's say if there are 10 independent claims, or 20 independent claims, or 2 independent claims, each claim may have a certain priority date. For a patent application per se as a whole, it is seeking a priority from one of the previously filed priority patent application. But for each claim that you find in the complete specification, that may have variable priority dates depending on in which application was that subject matter first disclosed. Okay, let's say if you have filed a provisional specification followed by under section 9(1), you have to file complete spec within a period of 12 months, and whatever is being claimed in the complete specification is fairly based on the subject matter disclosed in the previously filed application, which is a provisional application, then the priority date would be that of the provisional specification itself. Or if that claim of the complete specification, that invention which is being claimed, first time appeared in the complete specification itself, then the date of filing of that complete specification would determine its priority date. So basically, any application wherever subject matter was first disclosed and later on it may have been claimed, or on that date in the same application it may have been claimed, so you'll have to say where the disclosure was first made. Let us understand with a few illustrations. जैसे कि यहाँ पे इसमें we have tried to explain section 11 to A and section 11 to B. Here it's an example of Mr. A who has filed a complete specification, and uh, sorry, and yeah, so and he filed a provisional specification on 1st January. Let's say Mr. A filed a provisional patent application for an invention related to the new type of water filter using nanomembrane technology. This was a disclosure in the provisional specification. As you know, under section 9(1), one has to file, supplement this provisional specification with a complete spec within a period of 12 months. So what this complete specification um, gets is it has two claims. You find two claims. Claim number one is the exact copy paste of the disclosure from the provisional itself. Provisional has had new type of water filter, nanomembrane technology disclosed. Same is being claimed in the complete specification also. So as I said, wherever this subject matter was first disclosed or wherever it finds its fair basis, that would decide its priority date. So first of all, it was first disclosed in the provisional specification itself. So this claim 1, this claim 1 has been fairly disclosed in the provisional specification itself. Therefore, the priority date of the claim 1 of this complete specification would be 1st January 2020. While for the second claim, which talks about a water filter comprising an ultraviolet sterilization unit, this is the subject matter which was first found in the complete specification itself. It was never there in the provisional specification. Therefore, it was never fairly based on the previously filed application. For the first time, we saw its presence in the complete spec itself. Therefore, the date of filing complete spec, which is 1st Jan 2021, would be the priority date for claim number 2. Okay, so that is all that this section is saying, that wherever, whichever application, the fair basis for a subject matter was seen, that would account for its priority date for that particular invention. Which means if anybody else may have filed a patent application for ultraviolet sterilization unit before 1st Jan 2021, then that patent application would become the prior art against my complete specification. Let's go ahead. There is another subsection of section 11, which is subsection 3, as per which it says that if, let's say, there are two or more patent applications filed, let's say there is provisional 1, provisional 2, provisional 3, and then it is accompanied by such specification, and the claim is fairly based on the matter disclosed in one of those specifications, then the priority of that claim shall be the date of filing of that application accompanied by that specification. So there are basically two subparts to subsection 3, where it says if there are more than one prior filed patent applications. Okay, patent application provisional 1, 2, 3 and 4. And if afterwards, within a period of 12 months from the date of first filing, a complete specification is filed, and this also has four claims, claim 1, 2, 3 and 4. Then whichever provisional specification, this subject matter out of these four was first disclosed, that would decide the priority date of that claim. If, let's say, claim 1 is based on provisional specification 1, then for claim 1, provisional specification 1 would have been the priority date. If any of the claim is based on provisional specification 4, then the date when provisional specification 4 was filed, that would be the priority date for this claim also. So this is very easy. It is almost similar to what we just studied in the previous slide. But then the more complexity happens when the subject matter was partly disclosed in one and partly in another. That means one half of the invention was disclosed in provisional specification 1, let's say, and another half in provisional specification 2. Then the later filed specification would account for the priority date for that claim. Just say, for example, consider that, let me first just delete this one so that there is no confusion. So I just delete this one and take you through the illustration. So it says that, let's say, provisional patent application 1 was filed on 1st Jan 2020 and it covered the subject matter nanomembrane water filter. Then provisional 2 was filed which covered activated carbon filter as a subject matter. A complete specification when it was filed, only one claim was listed. This claim 1 was the combination of provisional application 1 subject matter and the subject matter which was disclosed in provisional 2. So this is how claim 1 is written: a water filter comprising both a nanomembrane and the activated carbon filter. So see, one half of this claim is coming from provisional 1 and the other half of this claim is coming from provisional application 2. Now what would be the priority date of this claim then? Would it be provisional 1 or provisional 2? It will say that when it is partly coming from 1 and partly from 2, then the later filed patent application would be the deciding factor for the priority date. So for claim 1, the priority date would be 1st June 2020. Let's move ahead. This talks about section 11(3)(a). This one talks about a complete specification which is based on a previously filed application in India. Let's say this is a provisional specification wherein complete spec was filed within 12 months and the claim of this complete specification is fairly based on the matter disclosed in previously filed application. All right. So that previously filed application shall be utilized to get the priority rate for that claim. Just say, in order to understand this, let's look at this illustration. It says Mr. A, who filed an ordinary application which is provisional spec 1 on 1st Jan 2020 disclosing feature X, which is nanomembrane for water filtration. Then on 1st December, exactly within 12 months, before the expiry of 12 months, he files a complete specification claiming exactly the same thing, a nanomembrane water filter. So the priority date would automatically be the priority date from the provisional because that's where the subject matter is coming from. Complete spec details are fairly based on the details provided in provisional spec. What is the meaning of fairly based? Fairly based matlab it was whatever was claimed in the complete spec, it found its basis, it found it details in the previously filed patent application itself. That means whatever are the contents of this complete specification, these contents are coming from its legacy patent, which is provisional specification. So details regarding what the invention is, which field is it from, what is the technical problem that it is solving, since how long the problem has been there in the market, anything, whatever has been disclosed in provisional, if it finds its entry in the complete spec and its claim, then the priority date of the claim would that be of the previously filed patent application only. So very easy. Now you go next. It is about section 11, subsection 4, about the divisional patent application. As you know, and we had done in the class in the previous lecture also, that divisional patent application does not cover any new subject matter. This is just an offshoot from the previously filed parent patent application. Which means if let's say parent application had claim 1, 2, 3, 4 and all of these were found not linked to each other through a common inventive step, then the controller would ask you to divide it. Which means the parent would now claim only those parts of the claims or those claims which are linked to each other and rest would be sent to the divisional patent application. So let's say parent application retains claim 1 and claim 2 while divisional captures claim 3 and claim 4. Now with respect to the priority date of these divisional patent application claims, it says that the priority would be antedated. Antedated matlab prior dated, meaning taking it back. to a previous date. Say, why? Because divisional patent applications claims actually emerged out of the complete specification only. So therefore the priority date would be decided, or it is antedated to the date of filing the parent application only. Um, so for example, in this case, provisional specification is filed on 1st Jan 2019 with covering nanomembrane water filter. Then as a second step, complete spec was filed exactly within a period of 1 year, covering two claims. One, which came from the provisional, which is water filter using nanomembrane, and second was a improvement over it, another invention, which is utilization of UV sterilization. Now, two different claims, and controller says divide this patent application into two because he counts these as two different separate inventions. So, parent application retains water filter with nanomembrane while the rest goes to the second claim goes to the divisional patent. Now, UV filter sterilization priority date would be the date where it was first disclosed. UV sterilization did not find its disclosure in provisional spec. It finds its presence in the complete spec first. So the date of the priority or priority date is antedated. Antedated matlab to a date which is earlier. That is 1st Jan 2020. That would be the priority date for the claim of divisional patent application because it was in complete specification filed on 1st Jan 2020 that we found UV sterilization. Date of filing of divisional application itself cannot give any priority to its claims because it has nothing new of itself. Everything that it has is coming from its parent patent application, which is complete spec. Section 11.5 mentions that wherever it gets a little bit of confusion, it might appear that one of the claims has elements of two priority dates, meaning of previously filed, uh, let's say there were previously filed specifications, and the claim comprises of all of those. In that case, section 11.5 tells us that the priority date of that claim would be the date which is earlier or earliest of those dates. So I'll just read it for you where under the foregoing provisions of this section, any claim of a complete spec would, but for the provisions of this subsection, have two or more priority dates. Then the priority date of that claim shall be the date of earlier or earliest of those dates. For example, if let's say claim 1 is based solely on feature 1, it covers only feature 1, and it has a priority date of 1st Jan 2020. Let's say these are the three claims of let's say these are the three claims of complete specification: claim 1, claim 2, claim 3. Before that, provisional specification 1 was filed, provisional specification 2 was filed. So claim 1, let's say, is actually coming from the subject matter disclosed in provisional specification 1. So provisional specification 1 covered feature A, while provisional specification 2 covered feature B. This was filed on 1st Jan 2020, and this was filed claim provisional specification 2 was filed on 1st March 2020. Now when complete spec is filed and one of the claim has the subject matter which was disclosed in provisional specification 1, so that would be the priority date of that claim, 1st Jan 2020. For the second claim, which is feature B, which was covered in provisional 2, then provisional two's date of filing would be the priority date for this particular claim 2, which is 1st March 2020. But there is, let's say, another claim which now combines the two, and it says there's a combination A plus B. Now there's a confusion that for A, we decided that the priority date would be 1st Jan 2020. For B, we decided that priority date would be 1st March 2020. Where it's a combination, so can there be two dates for this claim 3? So legislatures say that it cannot be. For you can seek a rescue under Section 11.5, then the if such a situation happens where it it might so happen that two priority dates are coming up, then you pick up the priority date which is earlier or earliest of the two dates or 2 to 3 dates. Earlier is this one only and this is the earliest also. So 1st Jan 2020 shall be the priority date for claim 3. Let's understand it by example. Let's say this feature A that we are talking about. Claim 1 is solely based on feature A. Let's say feature A is about a toothbrush. Okay? A toothbrush and it has bristles also. And so there is a head, there is a stem, and there is a cork or something which is joining the head and the stem. And then there are bristles in between. So basically, it's a toothbrush with normal bristles. But then provisional specification 2 is filed and they said those who have twisted teeth here and there a little bit. We need bristles that are also twisted so that these bristles can move across the teeth and it can remove the plaque or other debris, food debris. So he filed feature B in provisional specification 2, which covers exactly the same invention, but now instead of simple bristles, it's a zigzag bristles. Provisional 2 covered this, and now complete spec is filed covering a toothbrush as claim 1. Second, toothbrush with second is with bristles, that how these bristles are good to remove the plaque. And third is toothbrush, which is bristled, okay, together. Now in this case, it says that when such thing happen, because for toothbrush it's one different priority, for bristles which were crisscross another priority. When both are combined, it appears that two priority dates could be there. But we have to choose one final priority date, which will be the earliest of the two dates. So basically, section 11.5 simplifies matters by giving claim the earliest priority date possible, avoiding any confusion of the multiple dates. Section 11.6, subsection 6. This is saying that wherever, so it has given you a lot of tricks to find out the priority date in section 11.2, 3, 3a, 4 and 5. It says when none of these tricks are applicable and there is a confusion as to what will be the priority date, then it says you make your life easy. Then in those cases where none of the previous sections of section 11 are applicable, then you just simply pick up the date of filing a complete specification as the priority date for its claims. Section 7 is simple, which says that if this priority date is post dated, and there is a separate lecture of 1.5 hours just on post dating itself, you can look at it afterwards. So it says wherever a priority date has been post dated, wherein the original priority date was requested to be post dated to a new priority date, NPD, new priority date. O is OPD, which is original priority date. When you try to shift this, move it to a later date, then in that case, the claim, huh? The claim's priority date would be the date which has been newly post dated. A new post dated date would be the priority date. What does it say? The reference to the date of filing of application or of complete spec in this section shall, in cases where there has been a post dating under 9 or section 17, or as the case may be, an antedating under section 16, be a reference to the date as so post dated or antedated. So antedated, we have understood the concept. Section 16, divisional, we just covered it. And post dated is a new priority date which you wanted. Okay, now section 8, section 11, subsection 8. It is similar exactly to section 18.3, which we discussed in the lecture which was on anticipation. It says that the claim of the complete specification of a patent shall not be invalidated. Imagine that there is a patent which got granted, है ना? It says that this granted patent cannot be invalidated just for the reason that the invention was put to use or it was published after the priority date. So let's say if you have already filed a patent application, frozen a priority date, and you are yet to file a complete spec within 12 months. But immediately after priority date, if you start publishing your invention, exhibiting it in various conferences, start using it for commercial purposes, or you start using it for reasonable trials, for whatever, after the priority date of that claim, then that patent would still get granted, and your own disclosures or someone else's disclosures to your invention after the priority date shall not be the reason for invalidating that granted patent. Just a second. Okay. It also says that if, let's say, there is somebody else to whom the patent has been already granted, and this is a patent that has a priority date later than the date of your patent application or your patent, then your patent cannot be invalidated just because someone else got a grant to his patent before you could get a grant. So, for example, let's say Mr. B filed a patent application on 1st March 2020. Mr. C independently filed a similar patent application in July 2020. So, March, April, May, June, July, after 4 months. Certainly, when C was filing his patent application, Mr. B's patent application was a secret prior art. And we discussed about what secret prior art is in anticipation lecture. That means Mr. B's invention was not yet published. So when Mr. C filed it, this was Mr. B's application was not in publication because it gets published only after 18 months and he filed it. Mr. C filed it during the window of that 18 months. Now, C being a startup gets his application expeditedly examined and published early. And then this gets granted also within a gap of few months by December 2020. So everything happened very quickly with Mr. C. He had a later priority date. See, we have Mr. B, let's say it is me, Mr. Or you, Mr. B. He filed a patent application on 1st March 2020. That's his priority date. His priority date is earlier than that of 1st July 2020, which is the priority date of Mr. C's patent application. But by the chance, through expedited examination and all, Mr. C got a patent, however, granted early. So in this case, when the patent to Mr. B gets granted, then C cannot challenge or invalidate Mr. B's patent. This patent of Mr. B cannot be invalidated just because someone else got a grant to the similar invention, although with having a later priority date. Because here Mr. B is not at fault. He was not following a normal process, going through a normal window timelines. C got it expeditedly examined, got it expeditedly granted also therefore, but has a later priority date. So now you may question, would both continue to retain the patent grant? So means two granted patents for the same invention, then does the licensee has to go to both of them to seek a license? Well, that would be decided strategically by the businesses. Mr. B can decide to go to the court or file a revocation of Mr. C's patent saying that I have an earlier priority date. Mr. C's patent grant is not correct and it should be invalidated. He may also file a revocation or post grant opposition if it is still within a window of 1 year. Whatever the case may be, Mr. B can definitely contest the grant and contest that the patent granted to Mr. C could be invalidated. But vice versa is not possible. Mr. C cannot say Mr. B's patent should be invalidated because when you look at the priority dates, Mr. B has a earlier priority date than that of Mr. C's patent granted patent. Section 137, which is on convention patent application, is exactly the same. The only difference is instead of provisionals filed here in our country, India, here the provisional application are filed in some foreign application country. from where the priority is taken, and within 1 year convention patent application is filed in India. In that case also, how you calculate the priority date of those claims is based on exactly the same concept that we just discussed in section 11. There is no difference. When you stop the slides at these points, you can actually go through the examples. You will find that whatever we just discussed is exactly the same thing which is captured when it comes to convention patent application. So we come to the last leg of this chapter of this particular session, which is on calculating the patent term. Like I said, patent term, for the calculation of term of a patent, we never check the date of priority. We only check the date of filing. In case of PCT, in case of convention, date of filing is different from the date of priority. It could be different, it could even be same. Similarly, for ordinary patent application, date of filing could be same as date of priority, but you never use the term date of priority here. You only look for what has been the date of filing. Let's look at some examples. So this concept of this particular thing of the what is the expiry of a patent, what has been the term, what is the term? It's 20 years from the date of filing. See, it doesn't say date of priority, from the date of filing of the application. Let's say there are three examples. One, let us take it for the ordinary application, which is filed in our country, India. Let's say provisional application filed on 1st March 2019. Complete spec was filed on 1st March 2020 and the patent was granted on 15 January 2023. Now, what would be the expiry of this granted patent? Okay. So here we will see what is the date of filing. Now here, when was the application first filed in India? It was first filed in India on 1st March 2019. So although this is a priority date also, but this also is a date of filing. Because this is the date when for the first time you presented your invention, your application to the Indian Patent Office. Hence, the provisional filing date is the date of filing. So, you will calculate 20 years from 1st March 2019. So, this expiry will happen on 28th Feb 2039. Now, let us look at the example of convention application. How is expiry calculated? Let's imagine that in UK on 1st Jan 2019, a provisional patent application was filed, of which the priority was taken and convention application was filed in India under on 1st December 2019, that is before the expiry of 12 months. Convention application was filed in India and patent was granted on 1st March 2022. Now what will be the term of patent? Term of patent, as we said, it is 20 years from the date of filing. So what is the date of filing here? Is this 1st January 2019 a date of filing in India? No. This is the date of filing for UK. What is the date of filing for India? It's 1st December 2019. So 20 years will be calculated from 1st December to 2019. So expiry date would be 1st December 2019 plus 20 years, which makes it 30th November 2029. Let's look at the this one. Example 3 of PCT. The priority date is from the US, which is 1st Feb 2019. International filing date. PCT application was filed and it has to be filed within a span of 12 months as per sections of the Patent Act, which says that even for the PCT, the international filing date, the international filing, the PCT application itself is considered as a complete specification. This is the date, international filing date, when India was designated. It may enter India anytime within 31 months from the date of priority, but international filing date is the date when India was first designated. So therefore, international filing date would be the date of filing and 20 years will be calculated from 1st Jan 2020. So patent will expire on 31st December 2039. So basically the earlier priority date is relevant only for novelty purposes, but not for patent term calculation. So in nutshell, when you have to calculate the term of patent for an ordinary application, it would be the earliest filing date. This could be a priority date, this could be a date of filing also, but the earliest one. For PCT, no matter what, international filing date is considered as the date of filing. This is covered in section 171B. Then when there is a case of post dating, which is the next lecture, then in that case, what is the post dating under section 94, that you try to push the push it to a certain date. So section 9417, this is the post dated date. Matlab, where when you originally filed a patent application, now you made a request to to uh, postpone its date to a later date. So that new post dated date would be counted for, would be picked up for adding 20 years to it to find out the expiry. For divisional and for patent of addition, like I said, it's the date antedated because both are emerging from the parent only. So that would be the date of filing for both divisional and patent of addition. Both expires on the same day as that of its parent application, parent patent. For convention application, it is the 20 years from the date of filing convention application in India. So that's about patent term and the priority date. So you may feel free to ask me any question on the engagement group that you are part of. And for any issues, please come back. Thank you.